This is one of the very significant aspect. A court order has come and the bank has to make the payment of rupees 2,200 to the court. Next day a check issued by the drawer for rupees 2,828 has come, and at that time the bank had only 1,587 rupees. In view of the payment made to the court the previous day, the bank has to return the check for 2,828 to the collecting banker with the reason: A. Funds insufficient. B. Refer to drawer. C. Attachment by court. D. Garnish order received. The appropriate answer appears to be funds insufficient, but in fact the correct answer is refer to drawer. With the amendment to the Negotiation Act, introduction of section 138, importance is being given to funds insufficient as the reason whenever there is no sufficient balance in the account, when a collecting banker presents a check and the paying banker receives the check for payment. Earlier to that, the bankers used to use the term refer to drawer as the reason. The reason being, the banker and the customer relationship has to be kept in secrecy. The banker is under an obligation to maintain secrecy of the account of the particular customer. If at all any deviation, anything happens, then it is the responsibility of the banker to intimate the particular person, that is the customer, who is called the drawer. Nobody else should know what is happening in the account. With the introduction of the term funds insufficient as the reason whenever there is no sufficient funds, nowadays the bankers are returning the check with the reason funds insufficient. In this case, had this particular court order not come, probably the check received later would have been paused. Because of the particular court order has come about which the customer was not having any idea, the balance obviously has come down. In such cases, if funds insufficient is put, the other person can go to the court and seek justice under the provisions of the particular act. To avoid all those complications, the banker is expected to give the reason referred to drawer. Garnish order is the order of the court. When the direction comes from the court, the banker is expected to oblige whatever the direction of the court. The banker is expected to The court order is called the Garnish order. It is in two parts. The first part is called nisi. The moment the particular order is received by the banker is expected to record the date, time, because the Garnish order at the time of receipt is attaching the balance outstanding with the banker payable to the customer. So the banker has to immediately verify the account, freeze that account according to the order directions, keep it separately and intimate the court, and after receiving the reply from the bank, the Garnish order further will be issued, that is called final order. Based on that, the banker is expected to send the money either to the court or to the bank as per the direction. In this case, if they are going to use the word Garnish order received, it exposes the customer's position to others. Same is the case in the case of C, and A is not the appropriate answer. B is telling to the customer, please refer the matter to the person who has issued the check, so that the matter can be discussed and decided by both of you. So the appropriate answer here is not funds insufficient, but the appropriate answer here is refer to drawer. Please go through this. That means a customer, after having issued a check, has the right to request the banker not to make the payment on the check. In such cases, the banker will get in writing from the customer. They will verify the account, whether the check has already been honored or not. If it is not honored, they will give an acknowledgement. And when such a check comes in clearing or otherwise, the banker is bound not to honor the check, because there has been instruction contrary to issuing of the check. In one of the bank cases, what has happened? The banker has received a check instructions, in the sense the stop payment order has been received. The banker has given the acknowledgement. Afterward, the banker, overlooking they made the payment. Ultimately, when the customer questioned, the banker has said, we have given the acknowledgement in which we already mentioned that though we are accepting your request for stopping the payment, if it is done beyond the control of the bank, the banker will not be held responsible. Ultimately, in this case, the particular person went to the court. The court said, whenever you receive an order directing you not to make the payment, when you give an acknowledgement, it is your responsibility to see that the payment is not made. You cannot take shelter under certain conditions which you are going to put in general condition. Ultimately, the bank was directed to make the customer to get the payment. The answer is C. The customer would have to be compensated by the bank. The banker cannot take shelter because of their inefficiency. Bank QR has paid the check signed by the letter of authority holder in good faith. However, they overlooked the fact that last week the letter of authority holder's power has been cancelled by the drawer and duly intimated the bank in writing. The check bore the date of yesterday. Bank QR will not get protection, not a payment due course. Both A and B, bank QR to get protection since they have acted in good faith. The answer is both A and B. Paying banker X has returned the check wrongfully due to pressure of work. By the time they could realize necessary damage has already been done, X acted with negligence, not a payment due course. Both A and B, bank cannot be held responsible since the happening had not happened with intention. Acted with negligence, not a payment due course. Both A and B is the appropriate answer. Banker cannot take shelter giving certain reasons like pressure of work, this, that, all those things. A check issued for 22,222 had to be returned by the drawee since the balance of the account at the time of receipt of the said account has been only 2,345. Then the paying banker has to use the reason, refer to drawer, insufficient funds, either A or B exceeds arrangement. Here, the banker should have honored the check if the check was for 22,222 and the particular customer had minimum balance and the sufficient balance to meet the check. In this case, obviously, at the time of return, the balance was less than the amount of the check. So obviously, the banker has to return with the reason insufficient funds. A check has been issued by drawer Arun in favor of payee Arvind. The check has been collected by Krishna's bank. In fact, Arvind has entered the check in favor of Krishna. Then the payment will be received. Here, drawer is Arun, payee is Arvind, and Krishna is the third party. And ultimately, the payment will be received from Arvind's bank, Arun's bank, by Krishna's bank, both B and C. Arun is having the account. He expected his banker to make the payment to Arvind. In fact, Arvind wanted that payment should be made to Krishna. Ultimately, Krishna's banker is the collecting banker. Arun's banker is the paying banker. So it will be both B and C. From Arun's bank, it will be debited and it will be received by Krishna's bank as the collecting banker. Identify the inappropriate one, collecting banker, related to collecting banker. The collecting banker should act in good faith. The collecting banker should act with negligence. The collecting banker should collect for his customer. The collecting banker should collect only cross-check and not uncross-check. All the three excepting B are appropriate. The question is inappropriate, which is not correct. So B is not correct. The reason is the collecting banker should act without negligence, should have been there, but here it is mentioned as with negligent. That means without is missing. That is the reason. The appropriate answer is B. Yeah, in this question, the answer is amounts to conversion. Let us go to the next question. After F collected the amount on a demand draft, which has been chemically altered and potted with the money, U, the paying banker, demanded the payment from the collecting banker. F expressed their inability since the payee is not traceable. During discreet inquiries by U, affected banker, it has come to the notice that the collecting banker has not applied due diligence in opening the account of the payee. U is contemplating to proceed legally. U would succeed. F would get the order in their favor. U would not succeed, but F would not be spared. F, since L plus, U would have to bear the loss. Here, the collecting banker has not applied due diligence while opening of the account. Hence, the particular person cannot be treated as their customer. And as per section 131 of the Negotiable Instrument Act, a collecting banker can collect only for his customer. Obviously, in this case, for a non-customer they are collected, so the particular bank will be held responsible. In other words, when the other banker is going to file a suit against this bank, they would succeed. A is the answer. Which statement is appropriate? A post-dated check can be paid. A stale check can be paid. A post-dated check should not be honored. None. If you take from the angle of date, there are different dates a banker come across. This is today's date, 20/11/13. A check can bear tomorrow's date, subsequent date, earlier date as well. If a check today received by the bank and as the date as 20/10/13, that means it is the earlier date. This is called antedated check. If a bank receives a check bearing a date today, it is called post-dated check. A banker is in order making the payment on a check which is received today. When I say it is presumed, assumed, other things are in order, sufficient balance is there, everything is implied. They can also pay a particular check called antedated check, earlier date check, provided validity period has not been crossed. As of today, every check has got 3 months time from the date of the check. Earlier to that, we used to have 6 months. And a post-dated check should not be honored. A stale check should not be honored. Suppose today a bank is receiving a check bearing a date. This is called stale check, because when you compare today's date, 3 months are already been completed as on this particular check is concerned. The banker cannot honor the check. If the banker is honoring the check, then it is not a payment in due course. Similarly, if the banker is honoring this check, it is not a payment in due course. Here, the banker is in order. Here, the banker is in order. Yeah, antedated check, if it is not completing within, if it is not completing beyond 3 months, is valid. A post-dated check is not valid for the simple reason, as already we have seen, the account is a contract between the banker and the customer. The particular customer may die. That means the contract comes to an end. There is a possibility, maybe remote, there could be a garnish order. Tomorrow it comes, and today the banker makes the payment on a post-dated check. Then you will not obviously be able to make the payment to the court. So there could be a possibility he would have given a stop payment order after issuing the check, post-dated check, before it is received. So the banker has to be very, very careful about all these things. An antedated check which is not completed the validity period is valid, payment is agreed, and stale check, payment is not correct, post-dated check, payment is not correct. Today's date, when a check is received today itself, it is correct. Yes. A check has got a limitation period as well. Validity period is different from limitation period. Validity period is 3 months from the date of issue of the check. Limitation period is from the date of payment of the check, from the date of demand of the check, not payment, from the date of demand of the check 3 years limitation period is there. If cheque is not paid, 3 years limitation period is there for the other person to go to the court and seek legal remedy. That is a different aspect, and validity is a different aspect. Or has issued a check for commercial transaction for such and such amount in favor of W. W handed over the check to his banker D, who sent it for clearing. The check was returned by the drawee for the reason account closed. W wished to proceed against or for the reason insufficient funds. Though the reason appears to be the account closed, there are court decisions which says at the time of receipt of the check, there was not balance available to meet the check, so the particular customer can proceed against the other person based on the reason insufficient funds. The answer is C. Still, W can proceed for the reason insufficient funds. A check has been issued in connection with the payment due. Thinking that the same has been paid, the drawer has withdrew some amount. When the check in question came, the banker has returned the check with the reason insufficient funds. In fact, the shortage was only rupees 45. The customer became furious and charged the bank. Obviously, the customer expected, because of the relationship, association, he expected the check should have been honored. Paying banker will be protected under payment in due course. Drawer will not succeed. Drawee has acted within the parameters. All are appropriate. It is left to the discretion of the bank to honor the particular check, accommodate the check. If the bank takes the decision to return the check, theoretically, legally, he is in order. So the answer is all are appropriate. A collecting banker has sent a check for collection drawn on an upcountry place. Before the receipt of check by the paying banker, the drawer died, and the check in question has been returned for that reason. Since payee has been deprived of the payment, whom he should upcharge? Collecting banker, paying banker, both of them, none of them. A person dying is a natural phenomena, so that cannot put a blame on the banker. So obviously none of them. Ultimately he has to receive the money from the legal heirs of the particular person who has died, who was expected to make the payment to him. A mutilated check received without the appropriate certificate of the collecting banker has been returned for technical reason. The collecting banker presented the same after duly certifying. When it was received for the second time, the drawee returned the check with the reason insufficient funds. However, at the first instance, sufficient balance was there. That means when the check was received for the first time, there was balance available. But on technical ground, they returned the check. When it came next time, balance was not available. Drawee is responsible. Collecting banker is responsible. Paying banker is responsible. Drawer is responsible. Actually, if the particular banker has seen the balance, things would have been different. But before seeing the balance, the banker would like to see whether technically the check can be accommodated. Here, whenever there is a mutilation, that certificate has to come from the collecting banker. On the reverse of that, it should be pasted. And the collecting banker has to give a certificate, mutilation guaranteed. And he has to sign on behalf of the bank. Then only the particular payment will be considered as a payment due course, because it has been brought to the knowledge of the collecting banker. The collecting banker has requested, thereby they are taking the responsibility. So technically when it is returned, the banker is in order in returning the check. When it has come second time, when there is no balance available, the banker is in order in returning the check. The customer cannot question the bank for that reason. Drawee. Drawee is the paying banker. He is responsible. No. Collecting banker is responsible. No. Paying banker is responsible. Right. Okay. Drawer is responsible. Ultimately, drawee is responsible and paying banker is responsible is one and the same. Collecting banker is responsible. Another thing. Drawer is responsible, because whenever a person issues a check, it is his responsibility to ensure that at the time of receipt of the check within the validity period, the check has to be honored. For that, sufficient balance should be maintained by him. If it is not maintained by him, he cannot hold the collecting banker nor the paying banker responsible. The answer is drawer is responsible. Such things do happen in banking on a daily basis.